Assalamualaikum warahmatullahi wabarakatuh. My name is Raden from DBA 201022. Then I want to proceed our presentation titled about Federal Constitution. Federal Constitution. The Federal Constitution of Malaysia came into force in 1957. It is the highest law in Malaysia and it contains 183 articles. This is the fundamental law of the land which is used to measure the validity of all other law, shaped by two previous documents. First document is Federal of Malaya Agreement 1948, Independence Constitution of 1957. We proceed to the presentation.
Assalamualaikum, my name is Bassam bin Aiman, DBA 201024. I will continue on the Federal Constitution left by Raden. The supremacy of the Federal Constitution is set out in Article 4 and 162 and Section 73 of the Malaysian Act 1963. The purpose of this qualitative analysis is to examine and critically explore the extent to which the courts have been faithful and lawful to ensure and maintain the supremacy of Constitution. On the one hand, this paper will focus on the area of freedom of speech and association to see how well or badly the constitutional supremacy has been applied and respected. On the other hand, this paper shall examine the freedom and religion and equality before the law to determine the strength and weaknesses of the doctrine of the constitutional supremacy in Malaysia.
State Constitution. State Constitution is the statement of basic principles and highest law of a state. Every state reflects the diverse elements of its constitution, representing a microcosm of its people, tradition, and political culture. And then state government is headed by Menteri Besar and Ketua Menteri. So we go proceed to the presentation.
Alright, again, I will continue on the state constitution. State constitution, it includes matters concerning the ruler, the executive council, the legislature, the legislative assembly, financial provisions, state employees, and amendment of the constitution. On the other hand, the Sultan may act under his discretion on the following matters. First is the appointment of Menteri Besar on a state. Second is the head of Islam. And third is withholding consent to request dissolution of legislative assembly. That's all from me. Thank you.
About the legislation. Legislation refers to the preparation and enactment of law by legislative body through its locking process. The legislative process includes evaluating, amending, and voting on proposed law, and is concerned with the words used in the bill to communicate the values, judgment, and purpose of the proposal. And you may refer the other point. And that's all for me. Thank you very much. We proceed to other presentation.
Assalamualaikum. My name is Aqil Faizal. My matric number DBA 201017. Today I want to continue the topic. First of all, subsidy diary regulation. Regulation is a law enacted by Parliament. Can be referred as a delegate regulation. Delegate regulation is a regulation made by individual or body under power given on by Act Parliament. Subordinate regulation, secondary sub-regulation. Definition of a subsidiary regulation is meaning any proclamation, rule regulation, other navigation by law or other instrument made under any act, enactment ordinaries or other lawful authority and having legislative effect. Second, parent act means the enactment or ordinance that confers power to the relevant authority to make the subsidiary regulation. Example of the subsidiary regulation: Employee Social Security Supply Regulation 2006, Legal Admission Regulation 2006. Point 2, Judicial Decision Law. The Judicial Decision Law is underrated law. JD means law can be created through decision made by judge of superior courts and subordinate courts. Point 3. Custom. What is the custom law? The law of the local people as developed and handed down from time immemorial. Is a Malay, they call is adat. Custom law is an yet unwritten law that are found no rule as ever been enacted by the legislative authority. 4 conditions must be made to make it as custom law. First of all, it must be part of a long established story. It must be continuous and not broken or interpreted from one generation to the next. Third, it must be adhered to be respected and observed, and the native law system must be possess the authority to impose sentence on an individual who violate those native law. Example of the custom law is Adat Parti combined by State of the Negeri Sembilan Adat Temanggung custom law based on the Islamic principle and is applicable to all the other states except the Negeri Sembilan. Iban customary law applicable to the state of the Sarawak. Lastly, Dusun customary law is only applicable to the state of the Sabah in East Malaysia. That's all. I want to pass to the next presenter. Thank you.
Assalamualaikum. My name is Azray Zarym Kifli. My metric number is DBA201019, and today I will be presenting about principles of English law applicable to local circumstances. Malaysian law incorporates elements of English law. English commercial law and English land law are the two subsets of English law. Section 3 and Section 5 Civil Law Act 1956 stated the application of English common law and equity in Peninsular Malaysia. Next, Section 3, Subsection 1, Clause A. West Malaysia apply common law and equity as administered in England on 7th April 1956. The English commercial law as it existed on April 7, 1956 is applicable in Peninsular Malaysia with the exception of Penang and Malacca, according to Section 5, Subsection 1 of the Civil Law Act of 1956 and the lack of local law. In contrast, Section 5, Subsection 2 of the same Act is applicable in Penang, Malacca, Sabah and Sarawak because the law in these states is the same as the law in England in the same situation at the same time. Regarding the English land law, Malaysia does not have any jurisdiction over the tenure, conveyance, assurance or succession of any real estate or any estate, right or interest therein. The law that controls land matters in Malaysia is known as the National Land Code, except as it may be expressly provided for in the National Land Code. There is no exception for English land law. In the case of Syarikat Batu Sinar vs UMBC Finance 1990, it is shown that the effect of the local circumstances proviso in the application of English law that concerning the negligent failure of a finance company to endorse its claim to ownership of a tractor on the vehicle registration card and whether such negligence forfeits its claim. The High Court of Malaya noted that the English practice of endorsement of vehicle ownership claims by finance companies is different from that in Malaysia and Brunei, whereas the English practice is based purely on a voluntary arrangement. The Malaysian practice is based on statutory provisions, invoking the proviso to Section 3, Subsection 1, CLA 1956. Peh Sui Chin J. held the difference in law and practice in Malaysia constitutes such a distinctive local circumstance of the local inhabitants of West Malaysia that English cases on failure to register a vehicle ownership claim should not be followed. Instead, he followed a decision of the Brunei High Court. The learned judge added, "We have to develop our common law just like what Australia has been doing by directing our minds to the local circumstances or local inhabitants." Meanwhile, in Leong B vs Lingnam Rubber Works 1970, the Privy Council held that the presumption that a fire which began on a man's property arose from some act or default for which he was answerable has no application in Malaysia because having been displaced by English statutes, the presumption was no longer part of the common law of England on 7 April 1956. That decision was followed by the High Court Malaya in Lembaga Kemajuan Tanah Persekutuan versus Tenaga Nasional 1997. Okay, that is all from me. Thank you. Thank you so much, and I will be passing to the next presenter.
Assalamualaikum, my name is Muhammad Ikmal Hakim. My matter number is DBA 201021. I will present about the Islamic law legislation. Since Islamic law is regulated by state legislative assemblies, the law is published within the respective state gazette, except for the federal territories of Kuala Lumpur, Labuan and Putrajaya, in which the Islamic law is enacted by the Parliament and is published in the Federal Gazette. First, Islamic Family Law. Islamic Family Law, Federal Territories Act 1984 Act 303. Enact certain provision of the Islamic family law regarding marriage, divorce, maintenance, guardianship and other matters connected with family life. Extension and modification in its application to Federal Territory Putrajaya PUA 250/2002. Second point is Islamic Procedural Law Administration of Islamic Law, Federal Territories Act 1993 Act 505. Provide for the enforcement and administration of Islamic law, the constitution and organization of Sharia courts and related matters in the Federal Territories. Sharia Criminal Procedure Federal Territories Act 1997 Act 560. An act to make provision relating to Sharia Criminal Procedure for Sharia courts. Extension and modification in its application to Federal Territory Putrajaya PUA 248/2002. Third point is Islamic Criminal Law. Sharia Criminal Offence Federal Territories Act 1997 Act 559. Provide for Sharia Criminal Offence and matters relating thereto. Extension and modification in its application to Federal Territory Putrajaya PUA 251/2002. Next is Sharia Court Criminal Jurisdiction Act 1965 Act 355. Confers jurisdiction upon courts constitute under any state law for the purpose of dealing with offence under Islamic law, originally in an act as Muslim courts criminal jurisdiction.
Assalamualaikum warahmatullahi wabarakatuh. My name is Muhammad Aiman Yaakob and my metric number is DBA 193020. I will continue the presentation about Islamic law, which is evidence in Islam. Islamic law defines evidence as an evident indication of the commission of an offence by a certain person. This evidence can be either a testimony, a confession by the offender, a solemn oath taken by the plaintiff, or a testimony given by the plaintiff. The evidence required for a conviction differs from one offence to another. Some crimes require only 2 witnesses, while others necessitate 4 witnesses. Adultery, for example. So the last part is inheritance law. Inheritance law in Islam is the inheritance is the entry of living persons into possession of that person's property and exists in some form wherever the institution of private property is recognized as the basis of the social and economic system. However, the basic forms of inheritance and the laws governing them differ according to the ideals of different societies. The law of inheritance in Islam is based upon 5 main considerations. to break up the consideration of wealth in individuals and spread it out in society, to respect the property right of ownership of an individual earned through honest means. So to hammer in the consciousness of man the fact that man is not the absolute master of wealth he produces, but he is its trustee and is not therefore authorized to pass it on to others as he likes. To consolidate the family system, which is the social unit of an Islamic society. To give the incentive to work and encourage economic activity as sanctioned by Islam. So there is 4 persons that cannot get in an inheritance. First one is a fugitive slave who has fled away from his master. The second one is one who has murdered one predecessor intentionally or unintentionally. The third one is one who professes a religion other than Islam. And the last one is one living in Darul Harb cannot inherit the property of one living in Dar al-Islam and vice versa. So the sample case is the court rejected JJ's appeal regarding the inclusion of 3 million shares in the inheritance. So the Court of Appeal upheld the High Court's decision which allowed the application of the mother of the late Tan Sri Jamaluddin Muhammad Jarjis to include 3 million shares in Rantai Wawasan Sendirian Berhad in the list of her son estate. So that's all for my presentation and thank you so much.